So good evening, everybody. My name's Aadya.
Hello, good evening, everyone. This is Ankita this side. Just by way of a quick introduction, I primarily focus on the financial sector regulatory side and the fintech aspects and advise clients on these as a matter of routine. Aadya on the webinar here today focuses primarily on data privacy, cybersecurity, infosec compliances across different sectors, including financial sector. With, of course, the new act now and the constantly evolving regulations from different regulators on cybersecurity and infosec compliance, we thought it might be useful to do this session for a bunch of our existing clients based on the kind of queries we were receiving, both regulated entities as well as tech companies that are constantly juggling with how to marry compliances under one sector, regulator, as well as the other, along with the new act that is in place now. So this session will by and large cover a few fundamental things that we thought might be slightly more useful. Of course, like all our other sessions, we intend to keep this as interactive. So please feel free to pop in, ask the kind of questions that you think may be more practical and that you would want insights on. We'd be happy to kind of provide any sort of guidance we can. The idea for today's session is to kind of look at the compliance aspects for tech as well as regulated entities. How do you start the compliance, right? What are the factors that need to be evaluated to begin compliance at an organization level? What sort of cybersecurity processes, protocols are required? How to handle breach notifications? What are the internal processes you need to have? Who should be the point of contact internally for a breach notification? Which are the different bodies you need to inform? So everything about breach notification. Of course, data protection will be a part of the entire session, but we wouldn't deep dive into it in as extensively. There are, of course, other sessions we're doing on data protection and the new act. Then there's localization and transfers, again, with different regulated entities and different financial sector regulators come in localization requirements. Also, in some instances, restrictions on transfers. So to that extent, we'll try and address that across different sectors. A quick comparative analysis, and of course, whatever queries you have. Now, to just quickly begin in terms of compliance, and Aadya will deep dive into this in more detail, there are two things that we thought might be useful for this session. To look at compliances from a regulated entity's perspective, be it whether it's an entity that is governed by the RBI, or the SEBI, or the IRDAI, or the PFRDA, which sectors, how to go about it at an entity level, as well as what kind of obligations do these entities need to flow down to all their tech partners. It also becomes important, especially with the kind of financial products in the market where very often a group will have more than one license from one regulator. So how do you then look at compliances across these regulators? That's one part in terms of compliance that needs to be focused on. The other is there are a lot of fintech players that are partnering with these regulated entities. So while these directions do not directly apply to them, most likely these are obligations that are flown down to them through contractual arrangements. We've had instances where different entities have taken very, very diverse positions in terms of the kind of compliances that they expect fintechs to do. This could range from an ISO compliance to a SOC 2 compliance to PCI DSS, depending on the kind of services that you're rendering. So very often, whatever is applicable on the regulated entities, either as is or based on their internal policies, will kind of fall upon the fintechs as well.
Just maybe to then start thinking about the key considerations when you're dealing with setting up a cybersecurity framework. Now, for those of y'all who work in regulated entities, it's very likely that your systems and processes are already in place and factor these aspects in. But for companies that are not necessarily regulated by financial sector regulators, but either play a tech role within the ecosystem or are looking to create products that fall within the financial sector ecosystem, every cybersecurity plan must include these following considerations. And this is going to be slightly tech heavy and security standard heavy, but very useful to set out in terms of a framework. The first being, what kind of technology protocols are we as an organization going to adopt? Now, what these protocols are, and just as a caveat, sometimes are prescribed by regulators. If you all are technology service providers, very likely that your customers as regulated entities will require you to comply with. But the very first question in our view, when you're sitting together to create a kind of system, is questions on how we want our protocols to look. Do we need to think about, for example, a governance structure? Do you need to have a CISO? Do you need to have board approved policies? Are there specific security roles and responsibilities that we have identified and that we want to set out within an organization? From a project management perspective, do we need specific teams? When we are looking at specific products, are there processes that we need? Are there checklists that we need? When it comes to things like asset management, do we have a mobile device policy? Do we have a BYOD policy? Do we have these protocols in place? Do we use end user device management software? Is there a way for us to track employees and track what they're doing on their devices, always within the contours of the law, of course? Do we need to think about acceptable usage standards? Do we need to think about access control mechanisms? Do we have password management policies in place? That's the technical part of it. What about from an organizational perspective? Do we have a physical access and environmental access control protocol in place? Very simply, do you have a clean desk policy when you do come into office? These are just some of the key aspects, the key questions that arise, and they form the very, very basic framework that a small to medium-sized company should have in place. In our experience, a lot of the organizations that we sometimes interact with are a couple of steps behind when it comes to having these basic technology protocols in place. Do you have virus protection, anti-malware? Do you have firewalls? You'd be surprised at the lack of controls that we generally see. So as a part of your overall cybersecurity plan, it's a good idea to start thinking about technology controls and also mapping that against what the regulator requires or what your customers might require. So just by way of example, if you are a technology service provider that's looking to provide solutions to insurance players, it's a good idea to look at what the IRDA prescribes in terms of security controls, because it's likely that entities, insurers that are regulated by the IRDAI are going to require you as a vendor within the ecosystem to comply with these requirements. The second key consideration is, how do you think about outsourcing and how do you think about downstream obligations? Now, as a regulated entity, just by way of example, if you work in a bank or an NBFC, there are very, very evolved guidelines and frameworks that are set out by, for example, the RBI, that require you as a regulated entity to make sure that there is a contractual obligation that is passing down to your vendors. One thing that we sometimes see is that some of the smaller but still regulated players don't necessarily have due diligence mechanisms to verify that vendors are capable of complying with systems. So often what we see is during a negotiation process with vendors that are looking to provide services to regulated entities, questions come up on security standards and security protocols. And it just so happens that there was no initial due diligence that was done on the vendor to make sure that the vendor was actually capable of providing these solutions. And conversations often break down at the contract level. Instead of that, what we found very helpful is, as a part of your general procurement process or vendor procurement process, it's useful to create standards that you require your vendors to comply with. That, again, like Ankita mentioned, we're looking at this from a dual perspective, from a regulated entity perspective, but also from a vendor perspective. So from a regulated entity perspective, important, in addition to just having very strongly and carefully thought out contracts, to have a due diligence process that, while might seem like an additional step, actually creates a lot of efficiency within the process. That's one perspective. When you are a vendor, it's very important to preempt the fact that you are going to have your customers asking you these kind of questions. And again, it is an initial pain point. You are going to, if you are from the security team or IT team, I understand that there are always bandwidth issues. Often, from a legal perspective, we get a lot of pushback from IT teams and SecOp teams, but it's an initial pain that is useful to bear, just so that your contract management process gets a little easier, your interactions get a little easier. So what this means is, as an unregulated entity, doing a little bit of digging to understand what the regulator might require for companies like yourself, what market practices are, and what your customers might require, and then create a system that is well-versed and fluid enough and flexible enough to interact with regulated customers. So that is from an outsourcing and downstream obligations. Of course, I'm not touching upon the contracts, but your contracts also need to be very, very carefully vetted from two angles. One is from a legal angle to make sure that we've mapped every single obligation that ought to go into the contract, and also from a security standard perspective. So the third thing when you're thinking about cybersecurity considerations is looking at audits and certifications. Now, as a general requirement under existing Indian data protection rules, and I'm not talking about the new law, but I'm talking about the existing rules that are issued under the Information Technology Act. The ISO 27001 is a recommended standard. If you do have the standard in place and if you have sought certification, you are expected to, or the law at least treats you as having complied with the law's requirements. Now, what the law also requires you to do, if you do have an ISO certification, is to, on an annual basis, undertake an audit. A lot of companies and a lot of clients tend to overlook that. Every regulator requires its own form of audits and certifications. With respect to audits, sometimes these are internal audits, sometimes these are external audits. So, for example, with banks, there is an audit requirement that needs to be undertaken twice a year. If you are a regulated entity within the insurance sector, the IRDAI doesn't impose specific certification requirements on you, but it requires you to make sure that the cloud service providers that you engage, so that is, for example, your storage solutions, are ISO certified. If you are if you are a payment aggregator or a payment gateway, it's likely that PCI DSS compliance will fall on you. So again, the certification process is a bit of a pain point, often requires a couple of months of bandwidth to be undertaken within an organizational, within an organization. So it's important to identify what kind of certifications are good for you, what kind of certifications are mandatory, and how much bandwidth that will take. It is a question of manpower, bandwidth, and of course costs. So having a plan beforehand is very useful as opposed to reacting to a customer request. Just again, for some more context, certain markets prefer some certifications over the other. So SOC 2 compliance, which we are slowly seeing gain traction in India, was historically not very popular in India or the EU, but was more of a US client requirement, whereas ISO certifications were far more popular on this side of the Atlantic. We are slowly seeing that change, and we are noticing a lot of board-approved strategies that require technology service providers to have SOC 2 compliance. So again, it requires a bit of a market trend analysis as well to see which way clients are leaning, to see which way the ecosystem is leaning. But by and large, depending on the type of regulators ecosystem that you work within, there are different certification requirements that would apply to you. You do also need to prep for audits. Some entities get away with internal audits. Often you might require an external auditor. So it's important that your cybersecurity governance strategy covers that. This is, by and large, the key aspects that you should consider when you are jumping into cybersecurity planning. Just before I move on, if there are any questions, or Ankita, if there's anything, there's some perspective you have, happy to hear that right now.
I would just wanted to quickly add in about audit requirements, right? Now, every regulator, depending upon the nature of license you have, will expect you to comply with certain InfoSec cybersecurity requirements, and in some instances will have certain prescribed norms or require you to submit a SAR audit. We've had instances where the regulators actually questioning the kind of reports that are being submitted by different certain paneled auditors that are being used to conduct an audit, and how various aspects that are expected by the RBI in spirit and letter under the compliances have not been detailed out in a SAR audit report or the relevant report by the auditor. So these are all our aspects that are being scrutinized closely today. This was not the instance 2 years ago. We'd not had instances where the regulator would kind of question the audit reports that are being submitted. But we are seeing an increased trend where the relevant regulator is questioning these reports to try and ensure that all processes that are expected out of these entities are being complied to with the fullest.
Thanks, Ankita. If we can hit the next slide, thanks, Ajit. Another key aspect of your cybersecurity planning is planning for cybersecurity incidents. Now, just for some quick historical context, before 2022, and forget the financial sector industry, in entirety, you had the Indian Computer Emergency Response Team, popularly known as CERT-IN, that did prescribe certain incident response timings and incident response obligations on companies that had suffered cybersecurity incidents. Now, an interesting thing to note is that globally, when you talk about cybersecurity incident responses, that typically falls within the broad head of personal data breaches. So it's automatically linked to incidents that impact data of individuals. India follows a different approach. Now, in India, a cybersecurity incident is any kind of unauthorized access to an IT system. Technically speaking, even mistakes. So, for instance, an employee sending a wrong file or sending a file to a person who didn't have the necessary access control rights to access the file technically falls within the definition of a cybersecurity incident that is reportable to CERT-IN. Now, why I am touching upon this is that until 2022, companies had to report incidents to CERT-IN, but the law did not prescribe timelines for reporting, and they did not prescribe penalties for a failure to report the incident. Because of the rising number of cyber attacks that India saw, particularly since the pandemic began, last year, CERT-IN changed its tune. And right now, in India, if you suffer a cybersecurity incident, you are required to report the incident to CERT-IN within 6 hours of knowledge of occurrence. There are a few nuances that have crept in. So, for instance, if it's a personal data breach, if it's an incident that impacts critical infrastructure, if there is great harm that can be caused, then these incidents specifically need to be reported within 6 hours. What CERT-IN has done has, through informal clarifications, indicated that incidents that don't satisfy or create harm don't need to be reported within 6 hours, but they still need to be reported as soon as possible. The reason why we're touching upon this is that in addition to CERT-IN, every single other regulator prescribes some form of reporting obligation as well. So, for instance, if you are an RBI regulated entity, especially a bank, the reporting timeline to the RBI, in addition to the CERT, is between 2 to 6 hours. If you are a public listed company, you've got reporting obligations where you do need to disclose the fact that the incident occurred to the stock exchanges that you are listed on. So effectively, what happens is, if you are a medium-sized to a large-sized company that might fall under a broad head of different regulators, once an incident occurs, there are three or more folks that are created. You will at the same time have to make a report to certain. You will have to make a report to, depending on the type of entity you are, a report to the RBI, reports to stock exchanges. In certain cases, if you are a technology service provider, you might have to make reports to your customers as well, depending on how carefully your contract is structured. What this means is that you need a very, very effective internal breach response system. We've seen a lot of companies really struggle to deal with cybersecurity incidents simply because they haven't preempted the fact that an incident will occur. And should an incident occur, how they're going to handle it. What you basically need as a bare minimum is firstly a team that is equipped to deal with incidents. In our view, this team should include representatives of two teams. You do need a securities or SecOps teams, as we commonly refer to them as, but you also need members of your legal team involved in this specific incident response team, simply because of the fact that there are reporting obligations and there are legal repercussions for either reporting or failing to report the incident. In addition, very good idea to have a PR consultant on call, as well as making sure you have cyber liability insurance. A sophisticated cyber liability insurance program will offer these vendors to you. So should an incident occur, most insurance providers will have lawyers on board, forensic investigators on board, PR consultants on board to help companies navigate the system. So an incident response plan coupled with cyber liability insurance become very important. Cyber liability insurance is gaining traction in India. It is less sophisticated than some of the more some of the more sophisticated markets. So you will find that premiums are more expensive, but also at this stage, I don't think something that companies can do without, simply because you're looking at very, very high liabilities, if not legally, then reputationally, in respect of cybersecurity incidents. So what a company has to do to ensure that you are well prepared should a breach occur is first have a system to identify breaches. Sometimes it's the use of technical tools. Sometimes it is having a reporting system where either people within an organization or outside the organization can get in touch with the SecOps team and let them know that an incident has occurred. Sometimes it's a combination of both of these. Technical tools that can discover the fact that an incident has occurred, or reporting tools that allow individuals to bring this to your attention. Apart from the detection tools, what you need are well-trained incident response team personnel who are well equipped to deal with incidents on a very short notice. So just by way of example, our cybersecurity team has a 24/7 team that is always on call, simply because once an incident occurs, companies are required to report the incident within 6 hours. So you really need to have very, very quick and efficient response times. Once you have the IRT, it's also important to have the processes in place. Do you have board resolutions? Is your board aware of your IRP? Have you assessed the fact that there may be PR risks with reporting? So all of these go hand in hand. You will also need a system if you are a technology service provider to inform your customers. And if you are a customer, very important to make sure that your service providers have systems to report incidents to you. So that is incident response in a nutshell. And as a part of your general cybersecurity plan, very important to have in place. If we can hit the next slide, but one thing I also want to flag, which is things that we are really seeing a lot of, is ransomware. And to be fair, there is no single correct way to manage ransomware. What you do need, and what we often get questions from companies on, is how do I deal with ransomware? We've seen ransomware attackers sometimes ask for 1 Bitcoin or 2 Bitcoin. Sometimes we've seen ransomware attackers ask for $25 million. Regardless, the question is, should we pay ransomware? Number two is, if we do pay ransomware, what are the repercussions? So just again, there is no correct way to deal with ransomware, but some things that you all should keep in mind is that with ransomware, the moment you start making payments, you're opening a can of worms, because often you can't verify the identity of the attacker. Questions arise on whether we are violating or in breach of OFAC sanctions if the attackers are sitting in countries that fall within sanctions lists. Sometimes it becomes a question of accounting standards. How do we account for this? There are very evolved teams that can assist with the ransomware negotiation, with ransomware management, with ransomware payouts. And while it almost seems a little hello, sorry, I think there may have been a network issue at my end, but if it does seem a little, it's a little problematic to think about this upfront, in our view, it's always more sensible to prepare for these things beforehand, before trying to react. So having a ransomware strategy becomes very important as well. Now, just one last, sorry, go ahead, Ankita.
Quickly add in one more thing, and the way Aadya's kind of explained the different stakeholders involved when it comes to a breach or an incident response team that will have to deal with. You will have to involve a CTO. Depending upon the nature of the incident, you may want to involve a PR team. You will need your lawyers on board. You will need different stakeholders from the team internally as well as externally. What we've seen that has worked the best for our clients whom we've assisted with these reportings is to have an internal checklist and a protocol ready that the team has been trained on how to handle. It's an internal guidance note that is put together, that is approved by the board in terms of how to deal. So there is a clear guidance and a process that's upfront, and different stakeholders know what exactly needs to be done, as opposed to chaos when a situation does arise. So having that entire docket of step-by-step response, different teams that need to be alerted, different regulators that need to be informed, CERT, RBI, SEBI, customers, in what order, in what manner, what's the nature of, how should the breach be described, what should exactly be informed. Those are all things that have to be factored in. So a clear process of this sort that organizations can put together will really, really be helpful to deal with these situations once they arise.
And we've also got a question on whether India needs a regulation like the DORA in the EU to address ransomware attacks, or is India yet to be mature managing security first? This is, of course, a personal view, but I do think we have a long way to go in terms of security. We've seen regulators, including certain, we have seen the RBI, we have seen the IRDAI try to put together protocols all in a piecemeal manner. But I think, and this is just a personal view, I do think that there needs to be a far more stakeholder awareness. And I think the system needs to, and in general, the ecosystem needs to be a far more mature before we jump into this. Just in terms of, before maybe we can look at some case studies that Ankita and I thought might be interesting to discuss, a couple of data protection standards that we'd like to touch upon is that, first, in a lot of cases for B2C entities, consent forms the groundwork for how data is collected. Consent standards differ depending on the regulators. So, for example, under general data protection requirements, consent thresholds are fairly easy to match. But if you are looking at something like the digital lending guidelines, you require explicit consent. So consent becomes a lot more complicated. As a part of your technical protocols, very useful to have consent managers, which are plug and play tools, or depending on the complexity of your organization's size, and operations, you might require internal in-house consent management tools. But consent, because it forms the basis on which data is collected in a lot of instances, is an important mechanism that requires both legal teams and tech teams to collaborate on to make sure that adequate consent is sought. Data storage, data localization, and data transfers go hand in hand. We touched upon this at the beginning, but a lot of regulators impose security standards for data storage, for data retention, required data erasure and data erasure standards in respect of specific data sets. So it is important that when you are evaluating your data storage and data retention mechanisms, that you factor this in. In a lot of cases, as you can see with SEBI, as you can see with IRDAI, as you can see with the RBI as well, is that when you are outsourcing cloud services, including cloud storage, your agreements with your cloud service providers needs to be very carefully structured. The larger cloud service providers are, of course, far ahead of the curve. But if you are dealing with medium-sized cloud service providers, it is useful to evaluate whether their existing protocols will help you meet standards that are prescribed by the regulator. Localization, again, if you look at the DPDPA, the localization standards have been greatly relaxed. So there are no general localization requirements, but every sectoral regulator has its own requirements. The RBI's localization requirements are well known, but what is less known is the fact that the IRDAI has localization requirements as well. SEBI, in respect of certain types of data, prevents the storage and management of their data from being outsourced. So when you're dealing with unpublished sensitive price information, you need to make sure that you are not outsourcing it. It has to definitely be localized, but you can't use cloud service providers as well. So just considering your localization requirements becomes an overall part of your structure. Maybe we could jump on to some case studies right now. Just before we get started, there is a question on notice for consent in B2C. Should be a click wrap or be sent separately over email, since it has become imperative under the DPDP Act? So maybe just before we get onto the case studies, you are right. Consent has become imperative under the DPDPA. It's also got a lot more complex. So right now in India, accepting a privacy notice through a click wrap agreement where the privacy notice is 20 pages, that satisfies consent requirements under existing laws. But consent under the new law has got far more complicated. It needs to be granular, it needs to be unbundled, it needs to be informative. So just by way of example, if I am on a website and I am filling up a form, or there is a certain data collection mechanism that is happening, as an organization, you are required to provide me with a breakdown of every single personal data set that you are collecting, the purpose for which you are collecting it, how it is being handled, where it's going to, and actually require me to opt into each of these requirements. Now, how this is physically and practically going to play out remains to be seen. The government will be prescribing what are acceptable standards of consent, but it has definitely got more complicated. A click wrap is not going to be acceptable, and sending over email as well, I suspect, might be a little dicey. Now, it's likely that you will just to maybe add on to what I said, is that in respect of data that was collected before the law went into effect, you will need to provide users with a privacy notice. At this stage, I don't see why sending that notice via email will not be permissible, but we'll have to wait and watch for what the government prescribes. Just a couple of case studies that we thought may have been interesting to see how we practically play it out is that in often cases, especially when you are looking at securities brokerage firms, and this is just to explain the complexity of trying to put together a cybersecurity plan. But we were assisting one of the largest security brokerage firms put together a cybersecurity plan and an incident response plan in not just India, but also in the EU, the US, and Singapore. What ended up happening is that first you'd have to navigate this entire maze of regulators in India. You'd have to look at SEBI, you'd have to look at IRDAI, you'd have to look at the RBI, you'd have to look at the PFRDAI, you'd have to look at stock exchanges, and you would have to look at certain. So that's already 6 regulators that you have to navigate. On top of that, each of these regulators prescribes different security controls. So as an organization, you're required to map out every single security control and find the strictest control to adopt, just so that you are setting the baseline. Once you've created that, the question arose on how do we deal with cybersecurity incidents. So dealing with cybersecurity incidents meant that your internal incidents response plan would have to be structured in a way where we account for 6 different reporting requirements. Now, just to make this a little more complicated, because this organization had operations in the EU, Singapore, and the US as well, you would have to account for incidents occurring that had to be reported in the EU because of the GDPR and in Singapore because of the PDPA, which is their data protection law, which therefore meant that in both Europe and in Singapore, you have a different threshold for reporting incidents. In India right now, all incidents need to be reported to certain. In Singapore and under the GDPR, you have something called a harm-based reporting requirement, which means that the incidents that need to be reported often depend on the level of harm they might cause. If one person's encrypted user ID gets leaked, the harm that might cause is very, very different from a user base of 50 million users getting leaked, or a ransomware attack that holds up our hospital systems. So what the EU and Singapore require is a far more nuanced assessment of whether an incident needs to be reported. So this organization then had to split their incident response strategy into 2 parts. Number 1 is first identify whether the incident was a personal data breach, because that would trigger reporting requirements in Singapore and the EU, or whether it was a general, DOS attack that would have to be reported in India. You'd be surprised to learn that DOS attacks technically need to be reported in India as well. Then you need to create further breakdowns in terms of timelines, because in India it's 6 hours, but in the EU it's 72 hours. So then create the breakdown. Number 3 is have lawyers on board empaneled with your organization, so that when an incident occurs, you are spending less time negotiating fees and looking at scope of work, as opposed to working together with your legal teams and with your forensic investigators to actually get processes done. Now, the reason we are highlighting this is that often organizations, without realizing it, fall within the scope of different regulators. So your internal processes often require you to create gap analyses, require you to map different regulators' requirements, come up with the highest common factor amongst all these applicable security controls, and then adopt standards accordingly. Could we hit the next case study, please? Ankita, do you want to maybe take the identity verification systems?
No. So this case study is more specific to technology, fintech companies in general that work with regulated entities. You could be an identity verification company, or could be a digital lending platform operating as an LSP for different entities, for the NBFCs. Now, with fintechs, the position is slightly different. These are, of course, contractual obligations rather than obligations that stem from the law. And these obligations are very heavily negotiated. What we've seen in the recent past is that the RBI as well as the other regulators expect regulated entities to impose certain obligations on the tech companies that they partner with. With the new guidelines that have come in on IT outsourcing, depending upon the nature of service, if it kind of falls within outsourcing or material outsourcing, of course, there are added obligations that come in. But purely looking at it from a cybersecurity and infosec perspective, what most regulated entities would do is either annex a schedule into your agreement that expects you to comply with certain protocols, or will have extremely loosely worded clauses expecting you to comply with the best industry practices when it comes to your specific sector. While the latter may be fine to some extent to begin with, it's extremely open-ended, especially the kind when you tie it with the liability clauses that are being imposed on fintechs. So the obligation as well as the consequence of a fault or a breach has to be looked at very closely when the fintechs are partnering with these entities. Like I highlighted, we've had instances where, in the absence of a clear guidance on what ought to be followed, different regulated entities are taking the stance that you got to be an ISO 27001 compliant versus a SOC 2 compliance. Now, the kind of compliance requirements under both these standards and certifications are very, very different and very detailed, of course. So it solely depends on, one, the nature of service, to the relevant regulated entity that you're complying with, the size and the criticality of the services that you are rendering, which will all go into the relevant contract. We're also seeing increasingly all entities seeking unlimited liability for any data compromise event, as well as unlimited liability for any infosec cybersecurity breaches as well. So those are aspects we'll have to look at very, very carefully, especially while negotiating these contracts with the regulated entities. There is, of course, no clear prescribed certification for fintechs as of now, unless there are fintechs that are specific to a certain sector where regulations are mandated. Say, for example, if you are handling card information at any instance in a payment sector, you will be expected to comply with PCI DSS. However, these guidelines don't become important if you're a player maybe providing PG services and not PA services. So a lot depends upon, like I said, the role that you're playing and what you can negotiate with the RE that you're entering into a contract with.
And I think we are generally just seeing, from a contractual basis, a lot of push for very, very high security standards. And I think something that often gets overlooked is even within intra-group structures, looking at the different type of security measures that need to be implemented. So just when you are structuring intra-group arrangements where you might be a part of a group where different entities are regulated by different financial sector regulators, it becomes very important to structure that intra-group arrangement very carefully.
Ajay, should we move on to the next one?
Now, just what we thought was very helpful, and then we often use this as a ready reckoner, is to look at certain categories that we need to consider and look at the different regulators and laws that apply. And when I talked about that gap analysis and highest common factor assessment, this is a very simplified version of what a very complex structure would look like. So the couple of key heads that we examine is, what are the categories of data that we are trying to protect? Sometimes, is it only sensitive data? Are we looking at all types of customer data? In certain regulated segments, there are subclasses of data that might be held. So just by way of example, under existing data protection laws, data protection and consent standards only apply to sensitive personal data information, which is a very, very small subcategory of personal data. Within the RBI's regulatory ambit, if you are in the digital lending space, then it is customer data that gets impacted. But if you are, for example, within the PFRDAI regulatory ambit, sometimes it's just critical information assets. So every product, every business unit, every organization has its own classes of data that might need to be subject to protection. The next question is, how do you think about consent? When do you need consent, and what do each of these regulators prescribe? Similarly, when it comes to disclosures, what do we as an organization need to inform our users about? Does it need to be in the form of a privacy notice? How often does that privacy notice need to be updated? Do we need to have systems that permit individuals to get in touch with us to exercise access requests? Your analysis requires this assessment as well. And if we hit the next slide, what you do have is looking at policy requirements, looking at localization requirements, looking at data subject rights, and looking at appointments. So maybe to take this one by one is under existing data protection rules in India, regardless of whether you're a regulated entity or not, you will need a written InfoSec policy, which a lot of companies we are aware of tend to overlook. If you are an RBI regulated entity, depending on the type of entity you are, you'll need a cybersecurity policy, an InfoSec policy, sometimes an IT policy, a board approved policy, a cyber crisis management policy, and the list goes on. You might need disaster recovery and backup plans. You might need vulnerability assessment test protocols. So as a part of your gap assessment, useful to look at each regulator and useful to look at each of the policies that they prescribed. Similarly, when it comes to data localization requirements, depending on the type of entity you are, there will be additional localization requirements that apply. Sometimes, in respect of your processes, you will need to give effect to rights of individuals and have the systems in place. So just by way of example, we worked with a payment processing company that is headquartered in the US and that does business in India. One of their European subsidiaries had received a data erasure request. This became public knowledge, and then you had a lot of individuals in India that began to seek data erasure requests with the Indian company as well. Now, their global privacy team, because they were based on the GDPR, were willing to give effect to data erasure rights. But what we found in India was because they didn't have the technical tools to erase data, the CEO of the company turned around and said that to give effect to a single data erasure request, it's probably going to cost me, and maybe he was exaggerating, he was very angry for the fact that we had pushed for data erasure. It might cost him close to 1 crore to make sure that data was effectively deleted from his systems, from vendor systems, from partner systems, and to continue to ensure that erasure. So by and large, it's to give effect to data subject rights, and organizations will have to do that once the new law comes into effect. Important to have technical tools to help you manage the process as opposed to trying to manage it manually. Also, DPO appointments. So some regulators require data protection officers, some require grievance officers, some require specific teams. So as a part of your recruitment process, as a part of your tech team process, as a part of general data governance strategy within your organization, important to think about who these DPOs are going to be. Are there specific training courses you should take? Are there specific backgrounds in terms of tech and in terms of legal training that you might require? These are important questions that you should be asking. Just before we jump into the next just before we jump into the next slide, Ankita, I think maybe you would want to take this because there is a question on how do you see the trend in respect of limitation of liability clauses for data breach and confidentiality breaches? And is it a super cap at 2x, 3x, or unlimited liability? I mean, just from a regulated entity perspective, do you see any specific trends?
No cap at all. They will always insist on unlimited liability. It would be very, very, very difficult to get a regulated entity to agree to a capped liability for a data breach. Confidentiality, you may be able to convince them for a super cap at 2x, 3x, depending upon the commercials that are involved and the kind of information that you may have access to. But the moment this is significant personal data, if it's a product that is integrated with the bank's core system, I'm presuming the stakes are fairly high. To that extent, in most instances, it's always unlimited liability.
And we really don't see financial sector regulated entities budging from that. And what we are seeing with just larger customers, not within the FSR sector as well, is that there's a lot of pushback on caps on liabilities simply because of the risk of exposure at their end. So, which is why insurance, we mentioned it at the beginning, but cyber liability insurance becomes extremely important. And making sure you've got coverages that are adequate enough to cover the risks that you are potentially looking at. Just for some context, Certain has not yet imposed any penalty on companies that have failed to report incidents. The highest penalty under the IT Act is, I think, at last count, about 70 lakhs. So you are not looking at very high penalties historically, but that is going to change with the new data protection law. So the insurance becomes very important. Just a couple of other things before we sign off to keep in mind is that your incident response plan requires this careful mapping of your cybersecurity obligations, the timelines for reporting it, and the formats of reporting. So if you do look at the screen, you'll notice that banks have about 2 to 6 hours to report incidents. NBFCs have to report incidents within 24 hours. To SEBI, in certain cases, you will need to report incidents within 6 hours. If there's a technical glitch, you are required to report the technical glitch to stock exchanges within 1 hour if you are a listed company. So these timelines are so short that it's helpful to have a map and have a process that will help you comply with these timelines. Certification requirements, we've touched upon this before, but please do take an assessment and undertake an assessment to see how and what certifications apply to you and how often you must undertake audits. All in all, what this requires is a dedicated compliance, risk, legal, and technical team to kind of put their heads together to create systems. A couple of practical ways to do it is first undertake data mapping to understand what are the data sets that you have in place, how sensitive the data is, and whether there's specific sectoral requirements that apply to the data. Identify where localization applies, so you can make sure that you either have systems in place that permit for the localization to occur, and on top of that, that you do reopen your contracts with vendors to make sure they're localizing as well. Reopen contracts, look at contracts very carefully. Often what happens with technology service providers is that they may have historically agreed to security protocols within contracts that their tech teams aren't aware of. So that kind of gap assessment to understand what kind of security protocols you've agreed to is very important. When it comes to preparation, having these audits, looking at security protocols, looking at policies, and looking at certification mechanisms is a useful way to proceed. When you're dealing with incident responses, we've touched upon this. Look at containment, look at detection, look at recovery. Do not underestimate the PR damage. So have in place PR advisors. What I also think practically really helps is requiring your internal teams, not just your IT teams, but your legal teams, your business user heads, sometimes senior stakeholders, to undertake training exercises to understand what's at stake here. So that your training exercises should form a part of your cybersecurity readiness. Ankita, is there anything else you think that's useful from this perspective?
No, I think we've covered it all on this deck. I think this is a good step to kind of start with and start putting in processes and order.
Sudhir had one question: on which data privacy certifications do you recommend for organizations? Now, I do think that if you are looking for internal DPO type of training, the IAPP has some great courses, but you must be careful about which course you are undertaking. I think the CIPM, which is privacy management, provides a far more practical approach to how to approach privacy, as opposed to looking at something a little more theoretical like the CIPP. So I think the CIPM is a great place and a great course to look at. Oh, for organizations in terms of data privacy certifications. Okay, so Sadeed, when it comes for organizations, now, unfortunately, no law prescribes a data privacy certification. Data privacy compliance is an ongoing process. Anybody who says they are GDPR certified, that's a misnomer, because you are not GDPR certified, you are GDPR compliant, and compliance is a constantly evolving process. What are the security certifications you can look at depending on the organization you represent? ISO is a great place for getting, and it is the recommended Indian standard for getting together your security controls. But when it comes to actual compliance with data protection requirements, and Ankita, let me know if you disagree, but I don't think you can be DPDPA certified. I don't think you can be GDPR certified. What you can assure your customers is that, yes, we are GDPR compliant, which means that we are constantly, on a quarterly basis, on a half-yearly basis, making sure that our systems comply with legal requirements. Our organizational measures comply with legal requirements. But what that usually requires is working with your advisors to create a compliance plan.